I'm Paul Laney, the retired sheriff from Cass County, North Dakota, and the current vice president of national sales for Turnkey Corrections.
And I'm Lauren Matthews, and I'm the current social media and content specialist for Turnkey.
And, well, actually, you're not a specialist anymore. Somebody got a promotion. Right. She is now a content manager. Congratulations.
Thanks.
She is kind of a rock star and a diva, all mixed into one.
All wrapped into one.
But she's ours. Well, today you are listening to JailTalk again, and we have our favorite lawyer back in the house, Rick Hodsdon, the general counsel for the Minnesota Sheriff's Association, amongst a myriad of other things you do. He teaches for the School Police Staff and Command for Northwestern University, and now you're down to one full-time job because he retired from his other full-time job as a prosecutor for the Washington County Sheriff's Office in Minnesota, and we're so honored to have you back. What you do for us as we are able to educate across the country is huge, and we appreciate your time because we know you are a busy guy, and we keep getting asked to have you back.
Well, and fortunately, I'm only a little ways over the river, so it's over the river and through the woods to Turnkey I go.
There you go. There you go. So,
well, today we're going to talk about an issue that's become more and more prevalent in the corrections world. The topic of ADA and Title VII gender identity in the correctional setting. So, Rick, why don't you tell us a little bit about this topic?
Sure. And this is an evolving topic that is changing as our society is changing, as our landscape is changing. It involves two federal laws as well as a growing body of case law. The federal laws are the Americans with Disabilities Act and then Title VII. And Title VII of the Civil Rights Act of 1964. Many of us are aware that that covers employment, but it also covers public accommodations and facilities. The Americans with Disabilities Act covers exactly that. Americans with Disabilities, it's got 5 different titles. One of those has to do with employment, and the other has to do with, or other ones have to do with public facilities and accommodations. And jails, one of the very first ADA cases that ever was issued, rulings was ever issued by the United States Supreme Court, was that jails and prisons are covered by the ADA. And a lot of times when we think ADA, we're thinking, accessibility and width of cells and wheelchairs and braille on the elevators, etc. But it's much broader than that. It has to do with issues of housing, it has to do with programming, it has to do with a variety of other issues. So it'd probably be useful to give a quick little history of each of those as we get to the issue of gender identity as it relates to jails and correctional facilities. So we start with the ADA. The ADA has been around, like I say, since 1991, and where it starts to get interesting and evolutionary is how our society and views are changing, because the ADA protects individuals and requires a facility to engage in reasonable accommodation for someone who is covered by the ADA. So who's disabled for ADA purposes? And there are 3 different definitions. One is you are, if you have a mental or physical condition that substantially interferes with one or more of life's major activities. So, for example, if you were in a wheelchair, you're easily going to be covered. If you have major mental health issues, you're going to be covered. Another way you can be ADA covered is if you have a historical record or a history of having some type of disability. So, example that's often used in enforcement trainings with the Equal Opportunity Employment Commission, the EOC, who enforces this law, is if you had a cancer. You may now be in remission, but of course, cancer can kill you, and it very much interferes with life's major activities, at least for a period of time of treatment. Therefore, you would be covered even if you're now fully cured and in remission. And the third, more nebulous area, most nebulous of the 3, is if you are perceived or regarded as having a disability, then essentially you have ADA protections. Okay, so what's that all got to do with gender identity issues? Historically, our society has, and the term that's used in some of the older case law is gender identity disorder. When you identify with somebody that as a gender, or as a sex, if you will, that doesn't match your biology. And there's an evolving question now in our society that's really disorder. People go back to some of the initial diagnostic statistical manuals, some of the first editions, and being gay was considered a mental illness. And we see society now saying, well, gender identity isn't really a disorder anymore, as evidenced by several things. In the state of Minnesota, you have 3 options on your driver's license now, M, F, or X. The State Department for the United States government in passports has now given us 3 options. Again, M, F, or X. But if jails treat gender, your self-identification not matching your anatomy as being some kind of a mental health issue, as some of them still do, and prisons as well, then under the ADA, you've essentially had, as I say, if you treat someone as though they have a disability, they have a disability. That leads to the question of how do we handle these people in our population? The Title VII issue, again, has similar topics. Title VII prohibits discrimination, among other things, based on gender. So if we, it seems by definition, if we're going to treat someone differently, or especially because they're an X as opposed to an M or an F, then we're opening the door for a claim of Title VII discrimination, depending how we treat these individuals. And yet, on the other hand, as the folks who work in jails and prisons know, they also have a constitutional obligation to ensure that individuals are kept safe, and not be deliberately indifferent to their physical and other safety needs. If they are, then they are opening themselves up to a 1983 action for violation of their duty to protect. So if you're operating a facility, you've got about 3 different issues in play here as you're dealing with an inmate who comes into your facility and presents and perceives and articulates themselves in one particular area that doesn't seem to match their anatomy. And that's the headache that the jail.
I lived that exact headache. I had a situation where I had an individual come in who identified female, still had all the male anatomy, had not begun any of the process yet for the transition or any of that. We had a couple concerns on certain things, whether still the male part of it wanted to be housed in the female unit, and yet we had a duty to protect that individual, and we were trying to follow. This was years ago, so there wasn't a lot of the case law that there is now. And at the same time, we also had a duty to protect the females in the dorm if this turned out to be, still a male situation. So, man, we had a lot of time with our attorneys and a lot of time consulting with experts. And in that situation, we came up with the right solution and we followed through with it. So when you're talking about this, I'm like, oh, I remember that one. Because you can't mess it, you can't screw up. There's a lot of repercussions for that, which I'm sure you'll talk about in a little bit.
Yeah, and the other element of that, your duty to your inmates is, besides duty to protect and for all of your inmates, you also have a duty under the Constitution to provide proper and adequate medical care, to not be deliberately indifferent to medical needs, which includes mental health needs. So again, if you're in a jurisdiction that continues to say, well, if how you self-identify doesn't match your anatomy, then you have a mental disorder, as some places around the country still take that position, well, then essentially, if you're identifying that as a major mental disorder, then you also have just accepted a constitutional obligation perhaps to provide medical care about it. Mm-hmm. So we don't see this as much on the jail side, but in the prison side, where you're going to have people who are more long-term inmates, there's been, as you mentioned, Paul, a significant body of emerging case law as to whether or not a facility has the constitutional obligation to, for example, have the taxpayers pay for reassignment surgery, if that's where the person wants to go. Now, so far, the case law has tended to say, no, you don't have to bear that very large expense at the taxpayer expense, but you also can't ignore the situation. So the case law that has ruled, and there are 4 or 5 just in the last year and a half, and just so everybody in the audience knows how geeky I am, one of the things I do on behalf of sheriffs every year is I do an annual review of all the U.S. Supreme Court and Federal Circuit cases involving jails and prisons across the United States. I think it was like 1,000 or 1,500 cases that I last reviewed, and I prepare a summary of the several hundred most relevant, a couple of sentences of what they.
You sit down and you read 1,500 cases and write a review of 300.
Yeah.
On top of everything else you do.
Yeah, it takes a while.
I can imagine.
I'm like, wow.
So that's why I can tell you that there, if there's 4 or 5 cases in the
Told you we have an expert here.
You got to remember when I was a little kid, I read encyclopedias cover to cover too, so I've got a long history of doing dumb things like that.
Okay.
But almost all the case, there's no case law as of a month or two ago at the federal circuit level, at least, that says that there's a constitutional obligation for the taxpayers to pay for full-blown reassignment surgery. But there is pretty clear case law that says, however, you do have to, treat any medical-related issues, any mental health-related issues. Maybe it's therapy, maybe it's hormones. If you have somebody who is in the process of transitioning and arrives in your jail and says, I need estrogen or I need testosterone, or, to not do something has been held by the courts to be deliberately indifferent to a serious medical/mental health need. So this is a evolving, transitioning body of case law. I would predict sooner or later, as society becomes more acceptance of, you got to remember, 1980, the 1983 case law as well. In Title VII, when Title VII was adopted back in 1964, gender was binary. Well, now it's more like autism. It seems like it's on a spectrum. And where our court systems ultimately end on this, in terms of the treatment, the medical aspects of it, is an emerging area. Sooner or later, I can envision one of the more liberal federal courts, federal circuits saying, yeah, you have a constitutional obligation to fulfill this person's, transition. We'll see. Maybe I'm wrong, but I've gotten pretty good at reading tea leaves of where the courts go after all these years.
You certainly have a background. You mentioned the case law, Rick. Can you discuss some of the case law that applies to gender identity in jails, so that our listeners out here could research to learn more on this topic?
Yeah, it's a variety, and there's a variety of possible issues that crop up because, like I say, you've got 2 different constitutional obligations: the medical, mental health, the duty to protect. You also have the potential ADA, and you have the potential Title VII, all in play. This is just for your inmates. We'll talk later about staff. But like I say, so when you try and combine all those, the first question is, when this person comes into the facility, where do they go? If it's not going to be a catch and release, what a lot of folks that hadn't dealt with this before, their tendency, I think, because they didn't know, this is the first time they've experienced it, well, we'll put them in isolation. We'll put them in segregation. And of course, right away, that means you're treating them differently because of gender identity, which the Supreme Court has says transgender is considered sex discrimination under Title VII. You can justify that separate treatment if it's for documented reasons of safety, for medical treatment. It's no different if somebody came into your facility and had a contagious disease like tuberculosis or COVID. Yeah, you could treat them differently. You can isolate them as long as you can legally establish it's for their good or for the good of the rest of the population. But the default is, okay, anybody in this situation, we'll just put them in isolation or segregation until they're here. More and more the courts are saying, that's not good enough. You're going to have to do more than that. And certainly, if that's going to be your default categorization, or if it's going to be longer term, then one of your obligations, most of the time people who are in isolation, segregation, administrative or otherwise, have far fewer amenities than if you're in general population. They don't get the visits, they don't get the programming options, etc. And so that's one of the areas we're already seeing, again, the claim of sex discrimination is, because of this situation, I'm in isolation population, I'm on lockdown 23 hours a day, everybody else gets 8-10 hours in the day room, I'm clearly being harmed and discriminated against. So the question then starts to become, well, what can you do to make things be as much like the general population inmate for this person or these persons as you can? And we have a lot of precedent in that regard in terms of sex discrimination. Many sheriffs have gotten successfully sued because by females, historically, our jails in our country, this is changing as women become more criminal, I guess, but your population is far more male dominated. So we've seen many sheriffs who said, well, 95% of my inmates are male, 5% are female. So in terms of programming, the guys can have CD programming, the guys can have parenting classes, this, that, and the other thing. But because of mixing the genders, I just don't have enough critical mass to give these benefits, if you will, to the female population. The women in those circumstances have sued and have been successful. And I think that's a precedent to look to for this gender identity issue.
So, do Title VII issues then also cover the employees in their environments as well?
Yes, that's even an easier one in terms of reading the tea leaves, because the United States Supreme Court has weighed in on that very issue in October of 2020. There were two cases that got to the United States Supreme Court, and several of us predicted that eventually it would get there. We also correctly predicted the outcome, but we weren't sure what Supreme Court politics, where they would end up. But it was the two cases that got to the United States Supreme Court employment. One came out of the public sector, one came out of the private sector. And in one case, the person who was gay claimed that they were subject to discrimination in employment by virtue of the fact they were gay. And the other plaintiff contended discrimination by virtue of the fact, in employment by virtue of the fact of being transgender. And the court issued its ruling saying Title VII protects people against improper, illegal, gender-based discrimination. And Title VII has never only protected, for example, women. Many people sometimes think that Title VII protects those traditionally underrepresented people, but the court has clearly said, no, it protects everybody. A man can be as much of a victim of sex discrimination as a woman can. And now the court has said so can someone who is gay or someone who's transgender. So yes, it does definitely apply to the employment context as well. So then at that point, you start to get into the questions, especially with jails now, either by constitutional requirements or often by policy, such as jail rules, sometimes by state statutes. The issue of same-sex supervision has historically been a jail issue and a prison issue as well. And so then if you've got a transgender staff person, what units do they get assigned to? Do they get the men's pod, the women's pod, master control? I mean, most of our direct supervision jails now, there's a lot of interaction, as we all know, between the staff and the inmates, and yet if we're trying to minimize cross-gender supervision, in part for duty to protect, but also in part because the courts have always ruled that although inmates have a limited right to privacy under the Fourth Amendment in jails, they do have some rights under the Constitution and Fourth Amendment to privacy. And the primary example of that, if a staff position is intended to, part of the duties and responsibilities going to involve things like strip searches, change-out searches, frisk or searches, routinely observing people naked in the showers, etc. The courts have said, well, that's a valid basis to make an assignment decision to support the idea of same-sex supervision. So where does that transgender staff, where do they get assigned? And a number of sheriffs have contacted me across the country having this very same discussion. And it's unresolved because they're trying to balance Title VII obligations to protect the legal rights of these staff members, and yet also be aware they open themselves up for lawsuits by inmates for a Fourth Amendment violation.
So for our listeners right now, as you said, it's kind of constantly unfolding and things are happening. For our listeners right now, for our jail administrators, for our sheriffs, for our commanders that are all listening, what are some do-nots regarding this topic right now?
Well, definite do not, like I say, or do not just have automatically for inmates. Do not automatically put them in isolation, special population, simply if you have some concerns about how they identify. And if you have, because of your physical plant, you really don't have a whole lot of options, that's probably what's going to happen due to perhaps their physical size, condition, their risk of vulnerability, or sometimes our risk of being a predator, because we have to recognize it could go both directions. Then see what you can do from a facility perspective to provide as many of the same features, amenities, whatever. I don't know if anybody ever thinks of a jail as having amenities, but the quality, access to canteen, access to visitation as you would for everybody else in the population. In the staff area, again, don't make a knee-jerk reaction. Certainly don't take disciplinary action, refuse to hire somebody because of these issues. That we know the Supreme Court has said that's going to for sure buy you a potential Title VII EEOC suit. I think a conversation, an interactive conversation. The ADA uses a term of the interactive process. If someone has a disability and needs a reasonable accommodation, they're supposed to state what that reasonable accommodation would be, and then the facility, the manager, the administrator, whoever would do this, is supposed to engage in that interactive process to see if some or all of these accommodations can be made without undue hardship to the institution or, in the employment context, to the employer. Don't refuse to engage in that interactive process. If it's an inmate, process their grievances, interact, see what can be done. That doesn't mean they get what they want, but it means you've at least tried to get somewhere to where there's reasonable grounds. For staff members, again, that doesn't mean they get necessarily what they want. I want to be permanently assigned to master control. Well, in most jails, we know that's considered kind of the cushy plum soft job. Then you're going to, if you assign a staff member to that position, I could easily see the door swinging the other way, where somebody who's not, for example, transgender, saying, "I'm being discriminated against in my assignment because
I was next in line for that job, and now I don't have it because of that."
Yeah, I don't get that assignment because I'm a male that identifies as a male, or I'm a female, whatever. So, I think you're going to have to sort through that. My suggestion is, of course, it's like washing the car to make it rain. Think about this in advance, how you're going to handle it with your inmates. Think about it with your staff, and then you'll never have to worry about it.
Mm-hmm.
Safely travel anywhere from 1 to 28 miles per hour on the electric charge, or turn it to a standard bicycle mode at any time. These bikes allow for 50 miles to be driven continuously on one charge. Doing over 6 months of R&D has allowed Excel Power Bikes to take what is already in the market and bring it to a new level. To learn more about Excel Power Bikes, visit excelpowerbikes.com.
So then on the flip side of that, what are some positive steps that a jail could take to ensure that they are in compliance with the Title VII?
I think some positive things to do, as I said earlier, is planning. Figure out if you get into these situations, what your options are. Talk to your lawyers, because the federal circuits don't have the same universal view on this. Some of them are more conservative, for lack of a better word. Some of them a little more open. So find out what the case law, if there is any in your jurisdiction. On the staff level, I think openness with staff, encouraging people to be who they are, and recognizing this could have some, employment-related implications. But we do also have to take into account the same-sex supervision issue from an inmate's rights perspective. Mm-hmm. So
there's no easy answer, is there?
There isn't. And I can remember way back when, a long, long time ago, where the Minnesota Department of Corrections got sued by the Minnesota Department of Human Rights because they had a policy that would not allow women to work in the living units at the prisons. But they also said if you're going to get promoted, you have to have experience working in the living units of the prisons. And so ultimately that got resolved, and this is the national way one does it now to try and balance gender discrimination and inmates' rights, and that is selective assignment. These across-the-board rules about always and never, be very cautious about those. Are there ways that you can reconfigure your operations, your duties, responsibilities to maximize the employment opportunities for MF or X? And I think that's a positive, proactive way to do that. And nevertheless, engage in that interactive process with inmates and with your staff. Like I say, respond to the grievances. involve your counsel to keep you up to speed as to what the case law is, because it, like you said, Paul, it is evolving. 2 years ago, there was 1 or 2 appellate cases. This last year, I found 4 or 5. So it doesn't go away.
Mm-hmm.
Well, we are coming to the end of our show, and again, Rick is definitely available. We're capturing everything from a 10,000-foot view here. We consider for your classes are 4 hours, 8 hours long. Some of them. Rick's information is at the bottom of the screen. Rick's information is at the bottom of the screen, and if you're interested in bringing him into your facility, reach out to him directly and have a conversation with him. And his training's phenomenal. I can vouch for it. So with that, we are coming to the end of the show, Rick. Do you have any final words of wisdom? Because you always have a lot of words of wisdom, and you usually have a final word being a prosecutor.
Yeah, I think my word of wisdom is plan in advance and include your HR people and include your attorneys, especially your attorneys that are aware of these federal requirements. They can help you out.
Awesome. Well, thank you so much for joining us once again, and thank you everybody for listening. Make sure you subscribe to our YouTube and follow us on Twitter and Instagram. And as always, you can email us at jailtalkpodcast@gmail.com.
Well, thanks for joining us. I'm Paul Laney.
And I'm Lauren Matthews.
This has been Jail Talk. We'll see you next time.